Hello everyone, myself Sunny Goyal. Today I am going to give my presentation on the subject judicial process including theories of law and justice. My topic of presentation is judicial activism. Introduction of judicial activism. Judicial activism has always been a source of heated debate, particularly in recent times in both Supreme Court and the High Court judges. However, the word judicial activism actually connotes is still a mystery. Under the Indian Constitution, the statute is under the prime obligation to ensure justice, liberty, equity, and fraternity in our country, which has been laid down in the Constitution and is basic the introduction of the Constitution, which has been stated in our preamble. In the sense, the Indian judiciary has always been as a guardian and the defender of the Indian Constitution. Considering its constitutional duty, the Indian judiciary has played an active role whenever necessary in protecting the individual fundamental rights against the state injustice, excessive and arbitrary powers. Therefore, the idea of judicial activism is the exact opposite of the judicial restraint. Judicial activism and judicial restraint are the two terms used to describe the philosophy and the motivation behind some judicial decisions. Historical background. The concept of judicial activism found its roots in the English concept of equity and natural rights. The root of judicial activism in India is very difficult to find. For a very long time, the Indian judiciary has adopted an orthodox approach to the very concept of judicial activism. It would be wrong, however, to say that there have been no incidents of judicial activism in India. Some sacred and stray incidents of judicial activism has taken place from time to time, but they didn't come to the fore as the very concept was unknown to India. However, the history of judicial activism was traced back in 1893 when Justice Mahmood of Allahabad High Court delivered a dissenting judgment which sowed the seed of judicial activism in India. Meaning, since the judiciary has come to be recognized as an autonomous and a separate identity under the Government of India Act 1935 and subsequently under the Constitution of India, it would be wise to look at the time following 1935 from tracing its origin. A new rule is put in place and only to fix and resolve the present problem, but also to extend generally to all potential problems which are not presently back before the country they are likely to occur in the future. According to Black Law Dictionary, judicial activism is described as a theory of judicial decision making by which judges allow their personal opinion on the public policy amongst the factor to direct their decisions, usually with the implications that adherent to their theory appears to find constitutional violations and are willing to discard precedents. Judicial activism. Judicial intervention can be seen in three ways. First, by overturning any statute as unconstitutional. Secondly, by overturning judicial precedents. And thirdly, by reading the Constitution. In simple terms, judicial activism can be seen as a political role played by the judiciary, much like the other two executive, that is, executive and the legislature. Judicial activism is justified on the different grounds such as the fall of government which require the judiciary to provide assistance and the policies for the public welfare. The definition of activism differ from community to community. These categories are law teachers, businessmen, judges, police officers, administrative officials, students, etc. Any act which is perceived to be activism by one party but at the same time can become a judicial inactivity for the other group. The idea of judicial populism can be seen as associated with judicial abnormism, judicial chaos, judicial imperialism, etc. Judicial restraint, also known as judicial independence, is a synonym to judicial liberalism. Judicial intervention and judicial restraint are the words used to strike the right position of the court. Indian scenario. Judicial activism, as the modern terminology denotes, originated in India much later. This origin can be traced to the theory of social want propounded by David MacLeod. It was due to executive abuse and the excess that the judiciary has to intervene during legal proceedings. Let us look into the rationale behind such intervention. After independence from the British Raj, the executive has always looked upon the judiciary as a hostile branch of state. The view granted more momentum and popularity when the bureaucracy degenerated into the system for personal and the public gains. Exploitation and the corruption has been a part of existing political nature and structure. The masses were oppressed beyond imagination by the unbridled actions of the money power, muscle power, media power, and ministerial power. Judicial policy making can be either activity in support or in opposed to legislative actions or policy, but the latter is generally referred to as judicial activism. The nature of the judicial activism is making of the judgment under the mood and the time to times. Judicially policy activism promotes the cause of social change and articulates concepts such as freedom, equality, and justice. It got to be the arm of social movement. An activist judge triggers the legal system and make it a crucial part of Indian economic cycle. Important cases regarding judicial activism. The first major case of judicial intervention by social action litigation was the case of Bihar. It was of Husaina Ratta Khatun was the state of Bihar in 1980 in the form of written petition under Article 20. Some law professors exposed the barbarous condition of detention at the Agra Protective Home, followed by a lawsuit against Delhi Women Home filed by a Delhi Law School student and a social worker. In 1967, in Golaknath was the state of Punjab, the Supreme Court held that the constitutional rights of the Part 3 of the Indian Constitution could not be amended, even though there was no such limitation in Article 368, which only includes a resolution of two-thirds majority in both the House of the Parliament. Subsequently, in well-known case of Keshwananda Bharati, 2 years before the declaration of emergency, the apex court ruled that the government has no right to interfere with the constitution and the change to its fundamental characteristics. In Keshwananda Bharati versus the state of Kerala, the largest bench of India was constituted. In this case, as we all know, the Golaknath case was overruled, and it was made clear that the constitutional framework of the constitution could not be changed as what it meant to be a basic structure. It is still could not be clear, although some later verdicts have sought to clarify. The point to be remembered, however, is that there is no reference in Article 368 that the basic structure could not be modified. Accordingly, the decision has amended Article 368. A significant number of decisions of the Supreme Court of India in which it has played an active position refers to Article 21 of the Indian Constitution, and therefore we are dealing it with separately. Conclusion. Recently, the nation has seen instances of beneficial judicial activism to a large degree. Shibu Soren, a high-profile politician of Jharkhand, has been convicted of 1994 murder. Tencel world famous Sanjay Dutt as we all know, in Gandhigiri fame, was convicted under the Arms Act in 1993. Navjot Sindhu, who was ex MP also, and an ex-cracker with a gift from the Gap, was convicted of road rage killing committed 18 years ago. However, criticism of judicial activism, it can never be disputed that judicial activism has gone a great deal to improve the condition of masses in the country. Thank you.